That's all I see.
That's all you see in our system. So ma'am, you're of the understanding that there was a warrant of a new charge?
No,
Or calls the case people versus Jason Stevens.
Good afternoon, Your Honor. Olga Yermolenko on behalf of Mrs. Stevens, who's present.
Your name, sir?
Jason Stevens.
On behalf of probation, Your Honor, the victim in this case is present and would like to address the court.
All right, you two step back and. Hello,
hello, Judge.
what's your name?
My name is Kashmir Morley.
All right, very good. What would you like to tell the court?
When I was 24, just barely out of college, I applied for a job as a note taker for an exhibit design company in Ann Arbor. I met Jason for the first time as an interviewer. We talked about career goals and how I was really interested in a graphic design role, though I was willing to take on other hats to get my foot in the door somewhere creative. Months later, he would hire me as just that, a graphic design contractor for his company. For 2 years, I did small projects for him, working my way up to be his design assistant. I was 26 at that time. For those 2 years, we forged what I thought was not only a strong creative partnership, but a friendship. I look back over that time now and see that those were 2 crucial years. He felt my trust and my friendship as a form of predatory grooming. What did the title design assistant entail? Doing everything for this man, and I mean that quite literally. Jason would take me out to lunch one day on a long solo work trip back from Kentucky, where he and I would be sitting alone, to tell me that he and his wife were in an open relationship, something I would later come to find was a lie, to get in my pants. I remember feeling uncomfortable about him sharing this with me, his female understudy, who at the time was in an almost decade-long romantic relationship of my own. I chalked his transparency up to our close friendship and didn't put much thought into it again until he started bringing this up quite frequently. If you ever want to have some fun, let me know, he told me one day. I think you and I would be amazing together. I was, again, 26, and my long high school sweetheart relationship was falling apart, though no one knew, including Jason. Jason was 47 at this time and married with a child. Eventually, upon his probing, I would share with him that I was fresh out of leaving a long-term significant other. At this point, I was only 2 years out of college. My career was just starting to form. I was in a position of fragility in my life, and he knew that. I told him I didn't think it was a good idea. I told him that crossing that boundary would ruin our work relationship. He said to me words that would come back to haunt me. In September of 2023, you'll always have your job no matter what. The what became years and years of sexual abuse, emotional abuse, physical abuse, abuse of power. The what became me telling him no and it happening anyway. I noticed that Jason began taking away work tasks from me whenever I wouldn't sleep with him. Every day I came into the office to do my job, instead became a game of mental gymnastics for me. Is he going to tell me I'm fired again today for no reason at all? Will he tell me I'm no longer working on this project for no reason that he can give me? The abuse was constant. If it wasn't emotional, it was physical. It took me 4 years of abuse to realize that there was an end to that sentence that he never spoke out loud. You'll always have your job no matter what, unless you tell anyone what I'm doing to you. I sat in my office the day he assaulted me, staring at my phone where I had typed 911. My finger hovered over that call button for what must have been 10 or 15 minutes. If I called, I knew my job was over. I knew I'd wake up the next day unemployed. I knew he would fire me for telling someone about his inability to keep his hands to himself. But the alternative was to keep letting him hurt me, and I couldn't take it anymore. I couldn't take one more day of the abuse. I would lose a month worth of wages after making that call. I would spend thousands in therapy trying to make sense of what he had done. I would worry about paying rent. I would worry about feeding myself, about keeping a roof over my head. And then I would begin to worry that he would harm me further. In October, after the 911 call and Jason's arrest, he began to threaten me. He left a handwritten threat in my mailbox telling me to do the right thing in the middle of an impending trial. And I do say leaves because there was no forwarding address on that letter. Someone had to come drop it off at my house. And can you guess who was the only person at work who knew where I lived? When I didn't do exactly what Jason said, he started to show up at my house unannounced. He drove by my home and parked in front of my apartment dozens of times in an effort to make me feel unsafe, to make me feel like I had no other choice but to drop the charges against him if I wanted this to stop. Do you see a pattern? Jason has a back entrance from his house to his rental apartment, meaning he would not have to see me or be near my house at all if he wanted to check on his rental unit. Yet I continue to see him drive and park down my street. Any way imaginable that he could try to make me feel afraid is what I've had to live through and deal with since I called the police. When I didn't drop the charges, he started emailing me when there was a no contact order. And in every email, there was a threat. And every threat was sent from a fake name, from an email he and I set up for the sole purpose of setting up technology on the work site. I know this because I worked for him for 6 years. If Jason had actually wanted to message me something pertaining to work, he could have emailed me from his Jason @ handle as he had done for the past 6 years. But instead, he sends me back intellectual property that he stole from me from a fake name, minus anything I worked on for him, leaving me bereft for my own portfolio moving forward. And then tells me, I hope you got what you needed and we're in the clear, weeks before we're about to appear in court together. Jason J. Stevens, I am not afraid of you. Your threats do not work. It took me 6 months of intensive therapy to realize how badly he was abusing me. I entered the relationship with him consensually, but the abuse I endured was not consensual. The most disheartening part of this whole ordeal is being an up-and-coming young woman in a predominantly male profession and experiencing betrayal, mistrust, and abuse by someone I considered a mentor and with whom I looked up to. Jason could have made a difference in this world for not only young women like me, but young women like his daughter by holding his company to a higher standard than the one he created. And yet I am standing here today to hold him accountable for the actions he has done because he has chosen to do the opposite. I suggest battery intervention for Jason's probation. Jason chose to create a toxic workplace that is unsafe for any woman who steps foot on his job site. He created a world where women fail the moment they come to work. And if I have anything to say about that, that stops today.
Ma'am, I just want to clarify something. Thank you for that. Are you indicating that I think I'm aware of some of them, but that there was contact or alleged contact while this matter was
Yes,
at what points? Because
every month.
as I was listening to you, I don't think I have all of that, and I don't know that that's been taken into account with sentencing. Before you answer, Ms. Valera,
Yes, I don't have anything, Judge, so I don't.
Your
Oh.
Honor, we did raise the issue of the note on the document which was delivered by the defendant at the trial date, but the additional information, with the additional context, we did not.
no, okay.
I had
So
a,
that's what I'm a touch bit concerned about, that I don't have everything in front of me. I realize what you said in terms of where they were sent from, how you recognize them, whatever, but you still have those?
oh yeah, I had a whole FOIA document that I had forwarded, I think to Christine at one point.
Okay, so, all right. I think I want those.
Okay.
I want certainly Miss Polera to have those.
I can certainly give those to you.
The other thing that I'm wondering, and it kind of gets beyond the court's province, I think. You don't have this, you don't have this. As I understand that there was a work relationship, but there was also an intimate relationship at some point. Were we aware of that? Because here's my concern. Particularly given what's been requested, as I'm reading the recommendation from probation. I would think that this would need to more look like, or should look like, a DV sentencing as opposed to what it's charged as an assault and battery sentencing. I'm not saying go back and try to charge them. I'm not saying any of that. I'm just saying in terms of the structure of the sentence, given at least what I'm hearing here, I think that may need to be examined, particularly in terms of.
And Your Honor, I also know that Ms. Morley is asking for restitution. In the recommendation for probation, I was asking for a restitution hearing to be set, given light of her statement to the court, and probation being unaware of continued contacts and her indicating that she has proof of those. Probation would ask that the sentencing be adjourned, where I can reevaluate and look at everything to provide the proper recommendation for sentence, as well as maybe address restitution all in one.
Yeah, well, and that's what I was going to do that mainly because of the initial thing that was said regarding the contact, because I don't have that. And can't take that into account. I guess the other. Okay. And I realize at this point, it's in essence an allegation. The contact has occurred how often?
It was every month since he was arrested. So between October and March, I would say. That was in January. Yeah.
So there was contact in March?
Yes. For the very end of February to March. I can't remember the exact date, but it would have been like the last week of February, March.
Hey, ma'am, let me just ask you, when this contact would occur, what did you do with that?
I sent it to the cop who was dealing with all of this originally.
Pardon?
I sent it to the cop who was handling this case originally, or I called 911. So it's all documented.
Oh, well, I get that, but so you,
didn't get any notice from the officer in charge of this case whatsoever about any violations that were sent to them by the victim.
He had a separate what is the word? I'm blanking on the word for his arrest in March because of the stalking and harassment. No, not complaint. He had a warrant out for his arrest in March because of all of the stalking and harassment.
okay, hold on. There's a warrant, you said there was a warrant out for him?
Mhm.
Out of where?
14A District Court.
Do I have anything?
Bench one issued March 4th, but I don't see why
March 4th on this case?
on this case.
I issued the warrant for failure to comply with bond conditions. Is that still active?
No, I show it's canceled. It was canceled March 27th. It looks like it was the
When he came back, and that was part of the violations that he admitted to, that I'm taking into account in sentencing. So I get that one. But
that's all I see.
that's all you see in our system. So ma'am, you're of the understanding that there was a warrant of a new charge?
No, that's the same one that I'm thinking of.
Okay, that came out of this?
Yeah.
Got it.
Yep.
Okay. So, but so all of what you relayed to me today in terms of these contacts, those were sent to Pittsfield Township Department of Public Safety?
Yes.
Okay.
Or Ann Arbor as well, because I live in Ann Arbor. And so there was like a jurisdiction issue and the cop said that he couldn't handle anything that was not in Pittsfield. So when he dropped the letter off at my house, that was Ann Arbor. So maybe that's the issue too.
So some of this is in Ann Arbor.
Yeah.
Some of it's in Pittsfield.
Yep.
Okay, beautiful. All right. And the prosecutor doesn't. Okay. So we'll have to round that all up. Ms. Yermolenko, is there anything you wanted to say regarding the request for an adjournment regarding the?
I don't have a problem. We're not, it's additional contact allegations. We were aware of there were 2 email contacts in, I want to say January. That's what the warrant bond violation was for. We addressed it at the last.
Correct.
It was set aside. All those additional allegations I've never heard of previously, and I would like to see those police reports. So
And I do also want to note for the record, I just ran through my email. I did not get anything directly from Ann Arbor or Pittsfield with regard to a bond violation. We did receive an email from Ms. Morley regarding the FOIA the information she received from the FOIA. I also just checked our internal file system, and the only case for Mr. Stevens, which shows all of the warrants that have been submitted as well is this case. There is nothing.
There's nothing,
beyond
okay.
that. So there has not been an additional warrant request from Ann Arbor or from Pittsfield with regard to this case.
Got it.
Or, I should say.
And I spoke to the Pittsfield officer myself when we found out about the warrant. He did not mention any additional context, but once again, we were not aware of the additional context that being mentioned.
Okay, right. Got it. Okay, and so that I'm also aware, and the claim for restitution is for
Brenna, she was
general.
asking- Yeah, she's asking for, to cover therapy.
Got it.
She did provide some, receipts. We were taking a look at those today. I don't think that I have everything. I think that she may be looking, for this.
Got it. Okay, so May 8th probably not, it's gonna be too soon. Or, I mean, it's not too soon for me. I want everybody to be able to do the work. That's my concern. And Ms. Yarmolenko has risen and she probably isn't available. Of course not.
But I have another problem with the 15th of the court.
Well, no, we don't do,
Is that gonna be enough time?
what about the 22nd? Your work? Okay, ma'am. So what I'm gonna do is I will adjourn this to May 22nd, 2024 at 9 a.m.
I'm so sorry, Rich. I thought it was gonna be in the afternoon.
Whoa. Now you're throwing things? Okay, yeah. You thought it was gonna be in the afternoon.
I did, I am scheduled to be in Dearborn Heights this report all morning that morning.
No, wait.
I'm available in the afternoon, just have.
Is that one in the morning?
It is.
It is. But I will
also be gone that day. Is it possible?
oh, heck, I'm gonna get out of town too. So we'd have to go to the next.
June 12th at 9 a.m.
June 12th work for everybody?
With 10 a.m. work. I have a thing in front of the car at 9.
He'll wait. No. Okay, no, go there. Let us know. Well, of course, you're just right up the street. Yeah, that famous last words. June 12th, 2024 at 9 a.m. Court does call the case of the people versus Baktir Shadif.
Суд вызывает дело обвинения против Бахтияра Шадиева.
Counsel, state your appearance.
Пожалуйста, адвокат, представьтесь.
Good afternoon, Your Honor. Gregory Zlatopovsky, P41-341, appearing on behalf of Mr. Shadiev, retained, Your Honor.
Грег Златопольский представляет интересы от лица Бахтияра Шадиева на данном слушании.
The defendant is present.
Подзащитный присутствует или нет?
I saw him in the courtroom, Your Honor. He's there.
He is here.
Да, он
Jason.
здесь. Я видел его в зале суда.
All right. Counsel, have you reviewed the pre-sentence report?
Have
Адвокат,
you,
вы ознакомились с рапортом по предварительному расследованию дела?
I have, Your Honor, and I shared the contents with Mr. Bakhtiar Shadiev.
Да, я ознакомился с содержанием рапорта, и также я осведомил, проинформировал Бахтияра Шадиева.
It is factually accurate.
Рапорт достаточно правильный.
If the court
Точно.
allows me to allocate for a few moments on his behalf in terms of recommendation, Your Honor.
И также я бы хотел с разрешения суда еще сказать немного о Шадиева от лица, от его лица.
Go ahead, counsel. Is there something you wanted to say?
Your Honor, there is no question that him.
Hold on. Let the interpreter interpret.
Да, нет каких-то особых вопросов.
Okay, he did violate the bond condition.
Он нарушил условия залога.
Nothing happened since March 15th. That's over a month now. It's about a month and a half.
Ничего не произошло с марта 15-го, то есть это больше, чем месяц.
A few times that he did not retest. He did not test on time. He tested a little later, and the results were negative.
Несколько раз он вовремя не протестировался, но пошел на тест немного позднее, и результаты не отрицательные.
Your Honor, there is recommendation for a number of programs to be involved in.
Есть рекомендации в отношении нескольких программ, в которые должен быть записаться.
Usually, it's a great tool for somebody to gain from this experience.
Конечно, это большая помощь. Обычно эти программы представляют большую помощь для тех, кто их проводит.
But I believe the language issues will become an obstacle.
Но, к сожалению, я считаю, что проблемы с языком будут препятствия для получения такой полезной информации.
I know a Russian-speaking substance abuse counselor who is in Florida now, used to be in Michigan, but she still does it.
Я знаю психолога, который говорит по-русски, который проводит такие программы о злоупотреблении всех нелегальных, незаконных препаратов, но он был в Мичигане в данный момент, он живет во Флориде, но тем не менее он практикует.
She does it by Zoom.
По Zoom. Она практикует по Zoom.
Otherwise, Your Honor, I leave him to Your Honor to sentence him fairly and justly.
Также я оставляю на свое усмотрение, чтобы вы, Ваша честь, вынесли приговор по своему решению, по своему усмотрению.
Sir, is there anything you would like to say before I impose sentence?
Господин Шадиев, вы что-то хотели бы сказать, прежде чем я оглашу приговор?
Уважаемый судья, я полностью раскаиваюсь, приношу свои извинения, что вот так случилось, в моей жизни. Это большой мне уроком. Такого в моей жизни в 73 года не было. Я просто раскаиваюсь и очень сожалею, что так случилось. Извините меня, пожалуйста.
Your Honor, I really apologize. I'm really sorry about what
Так
happened.
случайно получилось.
For the
Приношу
first
извинения.
that happened to me, I'm 73 years old, and so until that time, nothing has happened really bad, and so this is the first time. I really sorry. I really apologize about what has happened.
The court does acknowledge this is not a serious misdemeanor as defined by statute.
Суд признает, что это не является, правонарушение не является серьезным правонарушением, которое оценивается как misdemeanor.
However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence.
Но, конечно, есть основания, чтобы наказание было наложено с вынесением постановкой на пробацию.
They include a SoberLink violation while on bond.
Также это включает, поскольку это было нарушение, связанное с злоупотреблением алкоголя и нарушением условий залога.
And the alcohol screening and assessment recommends intensive outpatient treatment.
Рекомендуется для того, чтобы вы были поставлены на тестирование по поводу употребления алкоголя, а также встречи и консультации с психологом.
As well as attendance at AA meetings and abstinence from all intoxicants.
И также посещение встреч, заседания анонимных алкоголиков и неупотребление, неиспользование алкоголя.
The court will follow the recommendations of probation.
И следовать тем рекомендациям, которые изложены в отчете отделения пробации.
with the stated rehabilitative goals to promote change,
с тем, чтобы вы прошли все реабилитационные мероприятия и достигли успешной цели.
prevent recidivism, and monitor compliance.
И необходимо будет следовать всем тем условиям и всему тому, что будет назначено по решению суда.
Therefore, you are placed on probation for a period of 18 months.
Я ставлю вас на пробацию на период 18 месяцев.
In court cost,
Нужно оплатить $850 штрафа и затратов суда.
$100 prosecution recovery cost,
А также $100 это за работу прокурора.
$100 recovery cost for the police agency,
А также $100 за полицейские услуги.
$540 probation oversight fees.
А также $540 за работу отделения пробации.
When can you have that paid, sir?
А как вы собираетесь это оплатить? Как скоро?
Ну, я оплачу.
I will pay it.
When did you say you could pay it?
Оплачу в течение там месяца-два.
Месяца два. I can pay it within 2 months.
Okay, this will be due by June 30th, 2024.
Вам дается срок до 30 июня.
There's to be no use of alcohol, recreational marijuana, or any illegal drug.
Также запрещается использование алкоголя, всех марихуаны и всех запрещенных психотропных препаратов, а также наркотиков.
You will be subject to testing as requested by probation.
А также вы направляетесь на тестирование, так как будет принято по усмотрению отделения пробации.
You are to complete an intensive outpatient treatment program.
А также необходимо вам пройти программу консультации с психологом.
You are to follow all recommended aftercare and provide status reports to probation.
И также нужно пройти всю реабилитационную программу и представлять своевременные отчеты в отделении пробации.
You are to attend one AA meeting per week with monthly verification to probation.
Необходимо посещать еженедельно встречи общества анонимных алкоголиков, отчет в пробацию.
You are to provide proof of victims' impact panel attendance to probation.
А также нужно посетить лекцию в отношении потерпевших от разных правонарушений и представить этот отчет в пробацию, отделение пробации.
The SoberLink testing device will continue for 60 days and until proof of intensive outpatient treatment is provided.
Также будет в течение 60 дней оставаться тот аппарат, который тестирует вас на употребление алкоголя, и потом это будет решено на усмотрение отделения пробации и с тем, чтобы вы представили отчет о реабилитационных мероприятиях, которые вы будете проходить.
I will order 93 days of jail, credit 1 day, the balance is suspended.
Таким образом, кредитуется 93 дня тюрьмы и взамен одного дня, и таким образом зачитывается разница.
That is all. Thank you.
Thank you so much, Your Honor.
Это все, и доброй удачи.
Thank you.
Ms. Polera?
Yes, Your Honor, I just wanted to bring to the court's attention that this case is on bench warrant status. Could you indicate on the file that the bench warrant should be canceled? Since he appeared.
I will, if, Madam Interpreter, if you could indicate that I will cancel the defendant's bench warrant.
I didn't understand.
The judge is
Sorry, you
canceling his
didn't-
bench warrant. Your Honor, I'm going to explain it to him afterwards.
All right, very good. Thank you.
Thank you so much, Your Honor. Thank you.
Thank you.
Thank you, Madam Interpreter.
Thank you.
Court does call the case People versus James Hagan.
on behalf of the people.
Sorry, Mike Gaddy, Assistant Public Defender, on behalf of Mr. Hagan, who's approaching.
James, sir.
James Hager.
I have before me a plea form that indicates the defendant is going to be pleading guilty to 2 counts of larceny by false pretenses, 200 to 1,000. That being counts 3 and 4. And those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken, or part of the false pretenses. If that's greater than 2,000, that would become the maximum fine. Upon the defendant's successful plea to that charge, or those charges, counts 1 and 2 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
Yes, Judge, that's correct. I have had Mr. Hagan execute a sentencing judge waiving their vice rights as well.
Okay, having sworn, you need to keep your hands out of your pockets.
Right hand. You solemnly swear and affirm the testimony you're about to give, the whole truth and nothing but the truth, so help you God.
Yes, sir.
State your name.
James Hager.
Sir, it is this court's understanding that you're going to be pleading guilty to 2 charges. Is that your understanding?
Yes.
First charge is, and the second charge also, is that of larceny by false pretenses. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. As I previously indicated, fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
You understand that that applies both to counts 3 and 4?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Yes, sir.
Understanding all of that, do you still wish to plead guilty?
Yes, sir.
To the charge of larceny by false pretenses, 200 to 1,000 as contained in count 3, how do you plead?
Guilty.
To that same charge as contained in count 4, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights for today, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. Copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty?
Yes.
April 3rd, 2024, at the location of 100 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
Yeah, may I have what, dear?
Please.
Were you at Briarwood Mall on that day? And had you come into possession of a credit card that wasn't yours?
Yes.
It wasn't yours?
Yes.
And you didn't have permission to use it, correct?
No.
And did you in fact use it at the Foot Locker?
Yes.
And did you make purchases of over $200?
Yes.
Your Honor, I believe we've met the burden for the underlying charge, the higher charge, as well as one of the.
One of the, gotcha. All right. On that basis, have I complied with the court?
The people are satisfied, Judge. Thank you.
Court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
May 16th at 1:30 before Judge Valvo.
May 16th, 2024, 1:30 before Judge Valvo. Bond in this case will continue. Court calls the case of the people versus Julie Von Pashon.
Assistant Public Defender Chinazza Carey, I can really, Your Honor, on behalf of Miss Julie Von Pashon.
All right.
Julie,
The court does have, state your name.
Julie Bumpachon.
Court has before it a plea form that indicates that the defendant would be pleading no contest to the charge of attempted resisting and obstructing a police officer, the 1-year offense. Upon her successful plea to that charge, she's pleading no contest. Upon her successful plea to that charge, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
that is our understanding as well, Your Honor.
That is correct, Your Honor.
May I have her sworn?
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you? Name?
Julie Bumpachon.
Ma'am, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes.
All right, let me explain 2 things about a no contest plea to make sure that you understand. First thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Counsel basis for the no contest plea.
Potential civil liability, Your Honor.
All right. So to that charge, she's sentenced before Judge Brownwell. I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yeah.
So to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You had signed an advice of rights form, is that correct? Okay. Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
The court has been provided and has reviewed Ann Arbor Police Department report for their case number 23-57430. Any objection to the court having reviewed that report?
No objection, Your Honor.
None particularly, Your Honor.
On a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Defense is satisfied as well, Judge.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this case will be
May 1st at 9 a.m. before Judge Perry.
May 1st, 2024, 9 a.m. before Judge Perry. Bond will continue. Ms. Von Pashon, how was Jersey?
What was that?
How was Jersey?
It was nice being with my kids. Thank you.
You're welcome. You do the same. Court does call the case People versus Lewis Jefferson.
On behalf of the people.
Assistant Public Defender Chinazza Carey, I can really, Your Honor, on behalf of Mr. Jefferson, who is approaching.
Today's date types up for preliminary examination. It's my understanding that Mr. Jefferson will be likely to waive his right to an examination. I have made an offer, so to speak. It's not been filing a habitual notice in this case.
And that is our understanding, and he is correct, Your Honor. Mr. Jefferson would like to waive his preliminary examination.
Is that correct, sir?
Yes, it is.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause the offenses that the offense alleged was committed and that you committed it.
Yes.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People, for the record, also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. The second.
As to the arraignment, We acknowledge receipt of the information. We stand mute and we ask that the court enter not guilty plea on his behalf and set this matter for a pretrial judge.
Defendant having waived formal reading, standing mute, the court will enter a not guilty plea to both counts. Pretrial in this matter will be set for
June 3rd at 1:30 before Judge Slay Monday.
June 3rd, 2024, 1:30, Slay Monday. Bond continue. And just go. Court does call the case People versus LaShawn Burrows.
Assistant Public Defender Chinazi Carey Akinruli on behalf of Mr. LaShawn Burrows, Judge.
Your Honor, last we were here, we began this exam. Sergeant Bradley testified in a Ypsilanti Police Department case. And at this time, Mr. West has not returned. So he was present the first day. We did until I think it was close to 5 o'clock. We adjourned. He appeared the second day and told us in advance that his father was having some type of medical emergency and that he would receive notice as soon as he went to the hospital. He received that notice before he could testify. My office has been in contact with Mr. West today. He indicated that he was going to get tested, and that's why he was not present today. So, Your Honor, at this time, I am not able to continue this exam today.
And Your Honor, we would be asking for dismissal.
Is this the only thing holding Mr. Burrows?
It's not, Your Honor. We waived those two OWI cases up to circuit court.
And he has bonds on those?
He does have bonds on this. And primarily because we weren't able to get the bond situation resolved at this level.
All right. So if I dismiss it, it's going to be without prejudice. It can come back.
And that's, we understand that, Your Honor.
You understand that, sir? Or, I mean, because my other option would be, given the circumstances, to find good cause to adjourn it out. Give an opportunity after we find out what his testing reveals for the to appear. That's my other option. But if it goes this way, you understand, Mr. Burrows, that you could be subject to arrest again on this case. I'll dismiss this case at this point. That's without prejudice.